Hey, what's up, guys? Aaron here. So let's talk about Celsius, what's come through the docket. So let me take a look first at the judge's schedule. So the next time we are before the court is going to be on this coming Monday, which is going to be the 16th. So this is where we're going to hear all about CEL Token, and there's probably going to be a ruling on CEL Token. So in this video, several of the documents are going to be about CEL Token, a lot of them coming from Otis, fighting for 81 cents. Wanting some different reports to be in front of the judge. Then we have a pro se creditor named Richard. He is sharing his objections to the board of directors that was picked and also the litigation oversight committee. He is saying that the orderly wind down will give a better plan, and he is agreeing with the U.S. trustee right here, which I'll get to in a moment. So going back to Martin Glenn's calendar, again, the next time there before the court is going to be Monday. Tuesday, he has Celsius on his agenda at 9. Wednesday the same, Thursday the same. Friday is going to be Celsius as well. The following Monday, I don't see it on the schedule. And then we have Tuesday, a very, very massive day. This is going to be Tuesday, October 24th. A lot of stuff happening with Celsius on his schedule. So the first document coming in from Otis, he is wanting a report done by Hussein Faraj to give his opinion on CEL Token. And Hussein Faraj is the CEO of a company called New Genesis. He has extensive background, or at least this is his Twitter bio, extensive background in government advisory services and financial systems. So in this 378-page document, Otis is giving Hussein Faraj's report, saying that the original report by Max Galka, who works at Elementis, is not good enough, and there are some major issues in that report. So Otis says that Mr. Faraj arrives at the valuation of 71 cents for CEL Token. So now we have, again, this very, very long documented valuation report of CEL Token. Now, I am not going to read through this entire thing. This is, again, hundreds of pages. But for all the people that are annoyed that Otis and other people are trying to push this, I do appreciate and I do acknowledge the fact that they believe they are right in their valuation of CEL Token, and they are going through the court to fight it. You know, whether or not they are right or not, they are doing things appropriately. And, you know, somebody put out this insanely large report about CEL Token. So this is what's going to be, I believe, officially ruled upon on Monday. And hopefully once this ruling is done, all the talk of CEL Token will be behind us. Otis also says there may be a conflict because Mr. Galka's company, which is Elementis, is funded by Alameda Research, a wholly owned subsidiary and controlled company of SBF and FTX, so Sam Bankman-Fried, who is currently being sued for $2 billion by the Celsius bankruptcy estate. And apparently, Mr. Galka was unwilling and unable to provide a precise value for CEL Token on the petition date. So this is a 34-page document going into all the things for why CEL Token should be valued at more than 25 cents. So again, I can recognize the grit of Otis and a lot of these guys fighting for their CEL Token. Whether or not it comes out to be in their favor or not, that's not up to me, and I have no say in that. And at this point, I don't want it to be zero, and I'd like people who had CEL Token to get their money, even if it is 25 cents or 81 cents. At this point, I really don't care. But I do appreciate the grit of a lot of these people who are fighting. So next, really quick, we have Richard Phillips, who is a pro se creditor, and he has pretty solid qualifications. So he's an investment banker with 20 years of experience. His work included valuations, fairness opinions, restructuring, and mergers and acquisitions. He passed several FINRA exams. He went to Caltech and UCLA, and he was interviewed as a candidate for the NewCo board and was not appointed to the board, and he is calling out some of the things that he thinks should be called out. And I'll just cover a couple of the things he said. This is a 28-page document, so I don't want this to be too long. But basically, he says he became outraged that the board did not contain a single creditor other than the two co-chairs of the UCC. So the UCC put 2 of their own members on the board of directors. He said that all this time they said the NewCo would be creditor-owned and creditor-controlled. But he says that this was not some open process and that White & Case and Perella Weinberg basically put people that they were already friends with that they wouldn't have any issues with on the board. He says that they should have put better people on the board of directors that would have better represented creditor interests and also people that were experts at Bitcoin mining and Ethereum staking. He says that the committee interviewed 9 creditors, so that means at least 6 creditors who were not committee members were qualified enough to receive an interview. But the committee only chose to select 2 people that were already on the UCC, Mr. Scott Duffy and Mr. DiFiore. He says he gets why these 2 people would have been on the board, and so do I. I totally understand it. But he says, I don't understand why no other creditors were selected to the board of directors. But here's where he talks a little bit about some conflicts that he sees. He says that Ms. LaPuma, who is on the board of directors, is a current client of White & Case. He says this is clear evidence that White & Case was trying to ensure that the committee appointed friends of the firm to both the board and the litigation oversight committee. And he says that this is basically giving White & Case the shoe-in to work for the board and the litigation oversight committee coming up. And these decisions were in the best interests of White & Case, but not the best interests of the committee and the creditors. And therefore, he says that White & Case knowingly and willfully breached its fiduciary obligations to its client, which is the committee. So then Richard Phillips came out with another document saying similar things. White & Case and Perella Weinberg did not recommend the best available candidates to the committee in addition to those creditors who applied. They instead, again, recommended people with whom they had pre-existing relationships. Now, personally, this is just me talking. I don't know if this stuff is true. I'm just reporting on what's coming through the docket. Now, I know the judge really just wants this to be approved, right? And the judge later on does say that his request will be denied. So I'm sharing this with you because I think it's important to know what's going on, but the judge is like, you know what? It's too late to do this, and we need to move on. So Richard also says that the third-party releases under the plan are not wholly consensual. Mr. Ferraro, the interim CEO, admitted as much on cross-examination when he stated that he was unaware that you could not opt out of the release if you voted yes on the plan. So the voting process, the actual ballot, a lot of people I've heard on Twitter were saying that it was not totally fair. And this is one of the things. If you voted yes for the plan, you were voting to release the third parties. Here the document goes on to read, almost all creditors want these bankruptcy proceedings to end so that they can finally have access to their crypto, which is totally true, that has been trapped in the debtor's estate since the pause 16 months ago. Creditors felt compelled to vote in favor of the plan, regardless of the releases, which the average creditor does not fully understand. I think this is a true statement. People want their crypto back, and that is why they voted in favor of the plan. So Richard agrees with the U.S. trustee, saying that the releases and exculpation provisions are exceedingly and unnecessarily broad. So basically, we should not just be releasing everybody who worked on this Chapter 11 once this plan is approved. He thinks that these are unnecessarily broad. He also says that the NewCo valuation is inherently flawed and substantially overstates its value. He then goes into the board of directors, some issues he has there, and ultimately he says that the orderly wind down should be what happens. So the orderly wind down, we would get more upfront crypto, we would get some mining equity, but there would not be this NewCo. We would not be funding a new company with $450 or so million of the estate's money. So White & Case comes out and says basically that Mr. Phillips' request to reopen discovery should be denied. And then the judge does say that his request to open discovery is denied. So I guess this is case closed. I still just wanted to report it to you just because, well, that's my job, reporting to you what's happening, what's coming through the docket. So on Monday, again, this is when the hearing on the value of CEL token as of the petition date will be, I believe, ruled upon. So right now I am talking to you, it's Wednesday night. Probably more stuff is going to come in the docket by Thursday and Friday. I could have made a video just summing it up on Saturday. I may make another video, but I am here to keep you guys updated on what's happening. So again, best case scenario, we get the first distribution of crypto by the end of this year. Whether or not we go into an orderly wind down or toggle into that orderly wind down is yet to be determined. If that happens, I would expect expect there to be an extra 1 to 3 months of delay in order to get that going, because that is a completely separate process. As always, I will keep you guys up to date, and definitely when there is a plan confirmed, I will be with you every step of the way as well. Thanks for watching, guys. Till next time, talk with you soon, and bye for now.